such a pleasure to be joining you back right here on the India Development Debate on ET Now. This is the second edition. Of course, we're talking about Justice Ranjan Gogoi. The second most senior judge in the country has set the cat among the pigeons once again. Gogoi, who was part of the Rebellious Four that protested against the master of roster system in the Supreme Court, has said what the country needs now is a revolution and not reforms. According to him, we need noisy judges and independent journalists as the first line of defense to protect our democracy, which is in trouble. Describing the poor state of affairs at the judiciary, Gogoi says it is like a workman without any tool and calls for a complete overhaul of the system. Although the Supreme Court has evolved itself into a good governance court through innovative interpretations of the constitutional provisions, that's not good enough to ensure social justice, he asserts. Gogoi's frank admission on the state of the Indian judiciary is the big topic of discussion and debate right here on the India Development Debate tonight. I'm Supriya Shrinate, and with me is a special panel. Justice Ashok Kumar Ganguly joins us, former Judge, Supreme Court of India, Prashant Bhushan, Senior Counsel at the Supreme Court, R. Jagannathan, Editorial Director, Swaraj Magazine, and Sanjeev Srivastav, a very eminent political commentator. Jaggi, if I may begin with you, Justice Ranjan Gogoi calls the judiciary and the media the last bastion of hope, he says. The judiciary is the last bastion of hope, which should remain uncontaminated. What exactly is he hinting at?
Well, it seems a backhanded assertion that it is contaminated at this point in time, because if judges come and say judiciary should be uncontaminated, there is a presumption that there is some amount of contamination, and it is not necessarily related only to the current judiciary, but it's been there for some time now. In fact, Prashant Bhushan's dad, I think in 2010, in open court said that 8 former CJIs have been corrupt and gave a sealed envelope with their names, and the court did not do anything. So obviously there is a lot that is wrong with the court in terms of the way judges are selected, in the terms of way judges compromise themselves by taking post-retirement jobs. They do this all the time. So I think he is right in identifying the problem, but let's see, in another 2.5 months he will be the Chief Justice. Let's see what kind of revolution it brings about in the way the court functions, in the way the court is responsive to the needs of the people. And I hope that he lives up to what he has promised through his speech, and I think he needs to live up to what he has claimed today in the, not today, in the speech that he made yesterday at the Ramnath Goenka lecture.
Fair point indeed. Can he live up to that? If at all he's elevated to the top post is really the big question. But I'll go across to Justice Ganguly. And sir, yes, media must be truly independent and also noisy, because our role is to reach out and disseminate information. But in the case of the judiciary, and Justice Gogoi has said the judiciary needs to be noisy today, if they are truly independent and above question, then their judgment will speak louder. And there is no need to join the babble. Does it not lower the majesty of the law if the judiciary is noisy as well?
No, it's not a question of judiciary being noisy. He must have meant by that comment that the judiciary must be very clear in its pronouncements, and where it is required, it must make its presence felt. I tell you, there is a very old observation by Lord Denning, very famous judge. He divided the judges into 2 categories, bold spirits and timorous souls. By saying that the judiciary should be noisy, I think Justice Gogoi said that the judges must belong to the first category of being bold spirits. I think he has said it very correctly, and if I may say so, very timely. It's very important for the judiciary to keep its focus right at the right areas, and not to compromise on issues which affect the lives of millions of people in India. And not only in India, it has a repercussion outside India too. So therefore, it's a very important thing, a point which Justice Gogoi has made, and I'm sure that during his tenure as Chief Justice, he will live up to this, what he has said. I have no hesitation in saying that.
Fair point. Hold that thought, because I want to take that question straight to Prashant Bhushan as well, and somebody who spends a lot of time in the courts as a senior counsel there, Mr. Bhushan, and you're known to speak your mind. Justice Gogoi talks about an independent journalist and a noisy judiciary. I mean, of course, Justice Ganguly says he's talking about the other category of judges who's supposed to be, with the spine, who's supposed to be straight. But must judiciary be noisy? And can deliverance of justice be vocal? I'm just questioning this from the point of view of, does a noisy judiciary risk and run the risk of corroding faith in the judiciary itself?
Well, I think he meant more than what Justice Ganguly just mentioned. I think he said both things. First, of course, that the judiciary must be independent, bold, must not be seen to be in partnership, and must not be in partnership with the executive and the legislature, because it is the job of the judiciary to hold them under check and protect the civil liberties of people from encroachments by the executive and the legislature. But by saying that sometimes, he said sometimes judges also need to be noisy. Now, what did he mean by this? He meant exactly what happened in January. He said he meant that at that time we had to come out and speak publicly, because we felt that the administration of the court was not being handled properly by the Chief Justice, that very sensitive cases were not being assigned in a proper manner, and were being assigned in a manner so as to have them disposed of in a particular way, and that puts democracy at risk. Now, the question arises, should the judges in the Supreme Court, when they are watching these things happen before their eyes, should they remain silent and not say anything about it? Or are the judges also equal citizens in this country, important citizens of this country, important members of civil society as well, who need to speak out when they see something wrong happening before their eyes, especially within their own institution, and even otherwise, if they see something horribly wrong going with democracy, then is it not the job of the judges to also speak out publicly, not merely in their judgments, but also publicly when they give lectures, talks, etc. Why should they not speak out? Are they not citizens of this country? Are they not entitled to speak out to protect protect democracy and the liberties of people?
Right. Absolutely. Mr. Prashant Bhushan, you raising the point about judges speaking out and the Rebellious Four at least speaking out because they are important citizens of civil society as well. I'm going to take that question across to Sanjeev Srivastava. And Sanjeev Srivastava, I don't think anybody can dispute or disagree with what Prashant Bhushan says, that if judges feel that there is something that's wrong within the institutions, it is only fair that they speak out. I'm only talking about the repercussions of speaking out. When the four judges came out in that unprecedented press conference in the month of January and put forward important questions, some of which remain unanswered to date, there was a sense of doubt that prevailed. People wondered what was going on in the judiciary, and which is why I use the phrase, does this end up corroding trust in the judiciary? Because you may be at the hands of the executive and the legislature, you may be helpless, but even the common man of this country believes I am going to get justice at the top court. And was that faith in some sense eroded?
See, I'm sure Mr. Prashant Bhushan knows and understands and can interpret Justice Gogoi much better than I can, but even I have a take on that. That when he meant about noisy judiciary, he actually used the word, like Prashant Bhushan pointed out sometimes. What he was trying to do was he was trying to reverse the order. The phrase goes as noisy journalists and independent judiciary, and so his was a double-handed take. He also said that journalists should be fiercely independent, which a lot of people are questioning these days, whether journalists are fiercely independent or they are also very partisan. And the second thing he said was sometimes noisy judiciary and judges. So I think his lecture yesterday, which I heard today on YouTube, I think he tried to strike a very fine balance. He was quite scholarly rather than coming across as a rebel, as the 4 judges came out in January. Rebel for a good cause, but still a rebel. So I think he was trying to strike a fine balance. He was trying to say all the things which would sound and mean well, that we all know what is the state of affairs in judiciary in terms of pendency and areas, and he said we will not give out figures, but still a truth needs to be repeated, even if it is said many times over. He said, quoting a French writer. Then he talked about revolution, not reform. We all know this, the kind of backlog we have and the kind of problems judiciary faces. It cannot be a calibrated approach. You really need to shake up the system. So I think he was trying to strike the right chord, somewhere not coming across too strident or too much on the other side of the government, because the fact remains that in October the Chief Justice will retire, Mr. Deepak Mishra, and it is anybody's guess in seniority. Yes, Justice Gogoi is there, but it's not the first time that a judge will be superseded, and it is also not the first time that judiciary is not
Sanjeev
very balanced.
Just hold your thought
so
on
I
that
think he was walking a very sharp edge.
Okay, Sanjeev Srivastava, just hold your thought on that very note, and I'm tempted to go to Jaggi, but I'll take a quick question to Prashant Bhushan before I go to R. Jagannathan. And Mr. Bhushan, quoting Hamilton, Justice Ranjan Gogoi said that while civil liberties will have nothing to fear from the judiciary alone, they will have everything to fear from the union of the judiciary with the executive or the legislature. What's really happening right now is this complete disconnect. Now, while the Constitution does carve out 3 distinct wings, in reality, is that sharp carve out possible? Because very often we see those lines blur, and that is where the contention really arises.
No, what he meant very clearly, and what he said very clearly, was that the judiciary should not be seen and should not act in a manner that it is in partnership with the executive or the legislature, because the Constitution lays out the role of the judiciary to act as a guardian of the rights, fundamental rights of citizens, guardian of the Constitution, and protecting democracy from abuse and protecting human rights from abuse by the executive and the legislature. So, therefore, with this being the role of the judiciary cannot be seen and should not be seen, and judges should not be seen as being very close to politicians, to the executive and to the legislature. This is what he meant, and that is absolutely the correct position in law and under the Constitution also.
No, I don't think anybody can dispute the fact that this needs to be a very, very distinctly different wing of the government, but I was really talking about the flashpoints that occur. And Jaggi, I'll come to you. Each wing has its boundaries. They should neither collaborate nor should they contend, is what they usually say. The judiciary has very often been found framing laws and economic policy, and politicians or legislatures have been upset about it. It's really the prerogative of the legislature. Let me quote Union Minister Arun Jaitley, who in Rajya Sabha, I remember in May 2016, had said, "With the manner in which encroachment of legislative and executive authority by India's judiciary is taking place, probably financial and budget making is the last power you have left." He called this the tyranny of the unelected. How do you strike that balance? How does the judiciary not hobnob with the with elected governments and with legislatures, and also does not have a sense of judicial activism at its play? I mean, policy making has to be the prerogative of elected legislatures because they will be held accountable to it. Very often we've seen judiciary play that role.
Yeah, I think so. I think in recent years, the Supreme Court has arrogated a lot of executive powers and legislative powers. It has even legislated taxes, like for example, the tax on SUVs. It may have been a good move. There is nothing wrong with it because of pollution and other things. But that's not what the judiciary should be doing. At the most, you should say the government should frame a law where you do the taxing so that the government does it. It's a directive for you to do something. You can't impose a tax on your own. I mean, you've been doing this repeatedly. Then you get into areas like managing the cricket board and other things. Is this the job of the judiciary? No, I think they've got into areas far beyond their basic ambit of interpreting the law and upholding freedoms. They've actually gotten into too many areas, and that's simply not acceptable. Not only that, I think you have not separated it. For the first time, when you had National Judiciary Appointments Commission, which had the sanction of the entire country in terms of the popular mandate, the assemblies, and almost unanimous vote of parliament, you struck it down. You should have read it down to say that so that there is no executive interference. What did you do? You kept the privilege of appointing judges to yourself. So you actually arrogated a power that is not there in the constitution. So this judiciary should actually act within, if it can protect freedom only when it acts within its limits and stays away from usurping executive power or powers that are not there given to the judiciary. So I think, I hope the revolution that Justice Gogoi has talked about when he becomes Chief Justice is about sticking to the limits but pushing the limits of freedom. That is where he should push the limits, not get into areas like lawmaking, which is not the judiciary stuff.
No, that's a valid point indeed, and I'm going to go across to somebody who's been in that high seat of being a Supreme Court judge. And Justice Ganguly, you know, Justice Gogoi yesterday said it's not a reform but a revolution what the judiciary needs today. Judiciary itself, many people believe, and many experts have pointed out that, has been most resistant to reforms. You know, greater use of technology in courts, even on NJAC for that matter. Where does the onus for reforming the judiciary itself lie? Does it not lie on the judiciary itself, and the revolution has to be within the judiciary and not outside with the elected government or the legislatures or society at large?
Well, I say first that what Gandhiji said is very appropriate, that if you want to change something, you must incorporate the change in yourself first. So you are talking about NJSC. NJSC is not an attempt to reform the judiciary. NJSC is an attempt to change the mode of appointment of judges. I think the appointment of judges through collegium system was evolved by the judiciary on an interpretation of the constitution. Because in order to ensure judicial independence, we have before us the example of supersession of judges, for no reason except for the reason that they had their views which the government did not like. You think of Justice, the great judge in that habeas corpus case, Justice Khanna. Why was he superseded? Was he at fault in any respect? Was there any deficiency in him? Why was Justice Hegde superseded? Why was Justice Grover superseded? Because these are the ills which were to remedied by actually it was remedied by the collegium system, and that was sought to be overturned by the NJC. So, and these areas that the judiciary making laws, you see, if you look at the constitution, Article 141, Article 142 gives the power to the Supreme Court to declare the laws. To declare the laws is wider than making the laws. This is a constitutional provision in our country that people forget. And on many times, say for instance, I can give you an example. When we delivered the judgment in that 2G case, many persons said that we are interfering in matters of policy. But if the policy is totally against the constitution, looting the exchequer cannot be the policy. That was the policy behind 2G spectrum allocation. Now, if the judiciary does not intervene,
but
how
Justice Ganguly,
will the constitution be upheld?
Right. But, you know, Justice Ganguly, what you're saying, and, you know, the contention to that is the whole idea was you should maximize natural resources. They should be auction only. Aren't these calls that elected representatives should be taking? Because if they are wrong, then they can be held to account by the public, by the society at large. They can be held at account by the voters. These are calls that the elected representatives should take. But I just want to carry on this debate and go further with Sanjeev Srivastava. And Mr. Srivastav, you know, it's very convenient for the elected government of the day also to pass the buck to the judiciary. You know, we debate against judicial activism, and we want the legislatures and the executive to do their role. But when it comes to contentious decisions, why should the courts be asked to take that call? Let's talk about Article 3, Section 377 on gay-sex rights. The government of the day has refused to take a stand. And, you know, they've just simply passed the buck to the Supreme Court. It's very convenient to do so when you don't want to bite the bullet. Isn't that an argument to also look at? So if you're creating space for judicial activism, then don't complain if they come back.
True. Same is the story with Babri dispute. The successive governments don't really cannot call the issue, so they have left this such a thorny issue in Supreme Court's corner, and Supreme Court is now expected to educate on these issues. So yes, and while you know, I think Jaggi raised that point that the cricket Supreme Court should not be entering into spaces like taxing SUVs or getting into cricket board's administration, but just look at how the cricket board was being run. And even after Supreme Court's education, we have the spectacle of a very senior journalist becoming chief of Delhi Cricket Association. So at the end of the day, as they say, the more things change, the more they remain the same. What has really changed? Supreme Court has come out with directives so many times on pollution. I remember in the 1990s when they pushed out certain industries, there was a dramatic fall in pollution level in Delhi, but it's back to square one. So at the end of the day, like you said, Supriya, not to collaborate, at the same time not to contend with each other should be the motto. Unfortunately, most wings of the government seem to have abdicated their responsibilities. Similar with judiciary. Where is the space and time in judiciary? So they take up a couple of big ticket issues about which we can debate, but the fact of the matter is the entire system is collapsing, be it judiciary, be it executive, be it legislature, be it the fourth estate. So we are living in very difficult times, very challenging times, and I don't think anybody has the answer. I just hope some well-meaning person, I just hope Mr. Justice Gogoi gets the job and he does walk some of the talk he is doing right now.
Right.
Because it is, like I said earlier, it is not the first time that you are raising questions about a current CJI or the current top brass. We have had CJIs accepting top plump posts in the past. We have had most corrupt people occupying that post in this country. So it's not an NDA specific phenomenon. It's a systemic problem.
Sanjeev, absolutely, it is not this government's problem. I think it has been a successive problem. I think it is a problem that dates all the way back to successive governments previously. But Mr. Bhushan, I have a more direct question to ask of you. The fact today is that there is no mechanism to ensure judicial accountability other than perhaps impeachment, which is far too technical, far too tough to do. Is that a desirable state of affairs? I mean, truth be told, while I'm not a fan of politicians at all, they've at least got some checks and balances. They've got to declare assets. They've got to declare affidavits when they want to contest elections. There is no such accountability as far as the judiciary is concerned.
No, you are absolutely right. We have been saying this for a very long time, that the only method of holding a judge accountable today is his impeachment. And impeachment is a political process, very difficult to initiate and very difficult to take it through. Firstly, you need to have signatures of 100 MPs on an impeachment motion, then the speaker or the vice president have to admit it, constitute an inquiry committee. The inquiry committee has to hold the judge guilty after holding a trial, and thereafter the matter goes back to Parliament, and as we saw in Justice Ramaswamy's case, even after the committee held him guilty, the matter still did not proceed because the Congress party abstained from voting in the Lok Sabha. So, and most political parties are unwilling and afraid to sign any impeachment motion against a sitting judge of the Supreme Court, particularly a sitting Chief Justice of the Supreme Court. And in this particular case, we saw that even after the requisite number of MPs had signed the impeachment motion, because the matter had become a publicized judicial scandal, even thereafter the Vice President declined to admit the impeachment motion. So therefore, this is a totally unsatisfactory process, and it needs to be replaced by a permanent body which is independent of the independent of the judiciary and independent of the government. And that body should be entrusted the task of examining complaints against judges and dealing with them.
Yes. Okay. I think on that note, I've completely run out of time here on this edition of the India Development Debate. It's been a fascinating discussion with all you very, very intelligent men talking about the Indian judiciary. Can't thank enough Justice Ganguly, Prashant Bhushan, R. Jagannathan and Sanjeev Srivastava for being with us. It really is a thought-provoking statement being made by Justice Gogoi. If he does get the top job in the apex court, he perhaps needs to work some of it. Judicial accountability has to be ensured, and perhaps judiciary has to open itself to many more reforms and not just a revolution. Apart from that, judiciary continues to be the last bastion of hope, and there is no denying that, and which is why the faith in the Indian judiciary cannot be shaken at any stage. Thanks very much for being with us on this edition of the India Development Debate.